initial disposition. May I have the names of our participants, please?
Lee Heiss, lawyer, guardian ad litem.
Nastasia Thomas, counsel for the department. Ms. McVeigh.
Megan McVeigh from the department, and I also have the foster care worker here.
Macy Moore from Catholic Church.
Michael Brooks, I represent the putative legal father, Jacob Bliss. Mr. Bliss.
I'm Jacob Bliss. Michael McFarland, representing mother. Please introduce yourself to the court.
Cheyenne Denies.
Thank you so much. All right, well, we can take the pretrial first. I would note, I don't have a proposed case services plan or any kind of initial report as it relates to mom's dispo, so.
I did do those this morning. I have a signed case service plan and then also a couple copies of a court report. I just didn't have time to send it out with it being so close together.
Were you able to meet with the mother about the case services?
Just the case service plan. We met at 1 o'clock right before this started, but this was the first time we could meet.
So we'll see what we might want to do about that in a few minutes. Let's tackle the father's case first. Ms. Thomas, any comments on this?
Your Honor, I believe that at the last hearing, at the preliminary hearing, Mr. Brooks represented that his client would, I believe, essentially like to release his parental rights. But given that we do have a parent who we would still be looking for reunification, that process looks a little different. And I don't know what Mr. Brooks' position or his client's position is on that, but we are willing to explore that a little more. But I don't know that we've done or gotten any information about a potential biological father.
Since that time, I got a call this morning from my client who said he has changed his mind and he wants a DNA test because he says he is not the bio dad. In fact, this lady was pregnant for 2 months before they got together even. And he just says he wants a DNA test, which apparently was ordered in Jackson County by the probate judge over there. And here is an order I was just handed regarding motion to remove name from birth certificate. Well, I don't think he was ever on the birth certificate, but he is on an AOP, which has been filed with the state, but he is asking that he be be allowed to take a DNA test along with the child. I'm, if I may, Dave, would you show this to the judge?
Any objection?
No.
Thank you, sir.
Ms. Thomas, any objection to me having a look at this? I don't know if you've seen it.
I have not.
Doubt she has.
Yeah, I don't know that Lee and I have. And I believe you said it was just a motion, Mr. Brooks.
It's an order concerning Cheyenne Denies versus Jacob Bliss, issued by Judge Rapley out of Jackson. I'd be happy to read it to you if you want.
No, that's okay. I'll look at it later.
That, or summarize it, and then I would pass my objection.
All
It
right.
orders a DNA test.
It's titled Order After Hearing Regarding a Motion to Remove Name from Birth Certificate. A hearing was held on March 12th, 2020 regarding a motion to remove name from birth certificate, at which time both plaintiff and defendant appeared in person. For reasons stated on the record, it is hereby ordered that the minor child shall have a DNA test within the next 30 days to determine whether the defendant is the biological father. It is further ordered defendant shall pay all expenses related to the DNA testing of the minor child. It is further ordered all prior orders not in conflict remain in full force and effect, executed March 12th, 2020.
Well, truthfully, I don't know why they bother with the birth certificate since that's not evidence of paternity anyway.
Well said, but I think the point remains that you would like cooperation in the DNA test.
Right.
All right, your position on that, Ms. Thomas.
I just, point of clarification, I'm sorry, and that order, defendant, who was the defendant?
Jacob Bliss.
Okay, And so Mr. Bliss is going to remain responsible for paying for the DNA? We're asking essentially for that order to be enforced?
Yes.
Okay.
I believe if
Okay,
you
as
ask,
in you have no objection, or okay, as in
All right. Yes, my okay was to the no objection. Sorry about that, Judge.
I
Okay.
believe if you ask the mother under oath, she's going to agree that that is the circumstances. He is not the father.
Well, I'd like to hear from Ms. Heiss on this, because obviously this changes the trajectory of our case.
Yes, Your Honor, thank you. I don't object to that being offered as evidence. However, the DNA test, was it performed then within 30 days of that order? I take it wasn't.
No,
So I don't know what the barrier was at that time, but a DNA test that shows him to not be the biological father only goes so far. When we find the biological father, there may be a motion under the Paternity Act to relieve this person, the legal father, of his legal obligations. But as a child's representative, even a non-biological child can be held to the legal duties of a father, and I would not want to leave this child fatherless. So I think all that work needs to be done. If he, I think, was going to set his case for trial, if he can give us longer to explore all this. I don't disagree with the legal father's point of view, but there are steps that we have to take, and just a DNA test isn't going to win the day necessarily. Was that a divorce case or custody case? Or just that motion standalone in Jackson? So other questions that I want to get answered.
Well, it appears to be a DS case code, which would indicate, to me at least, that there may have been a support action instituted at some point.
Okay.
Is your client paying child support, Mr. Brooks?
he is not.
Ms. McVeigh, in your research ahead of the filing of the petition in this case, did you find that such a case was determinative on the issue of paternity? I'm not seeing the addendum that discusses all other cases, and maybe I'm just missing it. But did you do a search to see if there were any other cases concerning this child?
Yes.
Did you find this one?
No, I did not. I must have missed it since it was in Jackson County and not Runaway County.
I have the AOP number if it helps the court.
It does. I have it in my notes and I'm still missing that. All right, Mr. Brooks, does your client have any idea who the father would be if it isn't him?
He says he does.
And the name?
Terry Andrew Donnelly.
Do you have any idea how to spell it? Anything else about this person?
No, but he does live in Jackson. It's not hard to find. I know a lot of people in Jackson. I mean, I know it's not required to find it, but I know he lives in Jackson.
I made contact with Mr. Donnelly.
All right, let's let Ms. Thomas run the show here for a minute. Deputy, would you swear in Ms. McVeigh Thomas?
Thank you. Ms. McVeigh, since our hearing on October 20th, have you had the opportunity to speak to either respondent parent about the potential genetic biological father of the child?
Yes, I actually made contact with him prior to filing the petition. He through Facebook Messenger, and he says he is. Mr. Terry Donnelly said that he is potentially the father, but he's not sure.
Okay. And did you ask if he was interested in establishing paternity?
He said he's interested in participating in a DNA test.
And is that something that the department can assist in doing, or is there a barrier given there's a legal father?
There's a barrier due to having a legal father.
And if the department was to assist in paying for Mr. Donnelly's DNA test, would that have to be part of a court order?
Yes, it needs to be part of the court order.
And other than Mr. Donnelly, Nias or Mr. Bliss indicated any other person that may be the biological father?
Not at this time.
Thank you so much, Ms. Your Honor, I have no further questions.
Okay, Ms. Thomas, just so you know, your mic is kind of cutting out here and there. We're getting it clear, but it's just dropping here and there. So I just wanted to bring that to your attention.
Thank you, Judge.
Questions, Mr. Brooks?
I have none.
Mr. McFarland?
No, Your Honor. I would like to call my client on this issue at some time.
All right, Ms. Heiss?
Just one question. Ms. McVeigh, do you know if the mother has been married at any time?
She has not been married.
Thank you. Thank you. Nothing for.
All right. All right, I would be inclined to grant in order to allow the exploration of DNA testing for your client, Mr. Brooks, as well as for Mr. Donnelly. But before I relieve him of his legal obligations to the child, I would like to see the results of those tests.
Makes sense to me.
So what I would be willing to do for you is to adjourn your pretrial to be heard at a later time. And I can do that at our next review, or I can try to set it for a time before that. What would be your preference?
Well, I don't pretend to know how much of a waiting list there is to do DNA exams, but depending on what that is will determine my answer as quickly as possible. I get the impression my client and his family want this testing done as quickly as possible, which means my client's got to be tested and the child has to be tested, as I understand it.
Ms. McVeigh, have you done any DNA testing lately to have we've got another volunteer for potentially a little more information.
Just on the DNA issue.
All right, come on up to the podium and give us your name, please.
Sure. Kristen Smith, foster care worker, Catholic Charities. I'm here with Macy Moore. But regarding this issue, I've actually done a lot of DNA testing at our office. We reach out to the agency, they send the kits, we do the swabs and then send them back. And we've gotten results back in like less than a week. So I would at least ask for a month just to be safe, but I think that we could get the DNA test completed and back within 30.
Well, I'm sure I could get my client there today, but I don't know about the baby.
We don't have a kit today. I have to reach out to the department first that does it and they mail the kit.
Okay. All right, does anybody have any questions for Ms. Smith that we should keep her at the microphone?
No.
I have one question. So Ms. Smith, the procedure that you're.
Do we need to swear her in?
Just let's see what her question is if we're going to keep going.
Sure.
I was just going to ask, because typically when we get the DNA test back, we have the photo of the child, the photo of the alleged parent, all of those things. Is that the same process that the test you are speaking of provides?
Yes.
Okay, thank you. No further questions.
Thank you, Ms. Smith. Suppose the next question is, practically speaking, do we have time for a pretrial in your case? Given the holidays. So let me look.
So that we are set for a bench trial in this case on 11/28. I don't know if we could maybe turn that into a pretrial. I don't know if it does. Yeah, I don't know if it does good with whether DNA will be back, but you can hope.
Any objections?
No, Your Honor.
No objection.
My client will not have to appear, correct, Your Honor?
Yes.
And we take no position.
Very good. So we will conduct the pretrial then on November 28th at 2:30 p.m.
November 28th at 2:30.
And in the meantime, the pretrial order will reflect that the department is asked to conduct DNA testing for Mr. Bliss as well as for Mr. Donnelly and the child. Okay? Yes. Very good. All right, Mr. Brooks, are you going to continue with us this afternoon or?
I have a 2:30.
So any objection to Mr. Brooks's request to be released for the day then?
No.
No
Oh, Your Honor,
objection.
I was gonna ask his client one question, so I was intending on calling him for one question.
What was your question?
I was gonna be that he met my client after she was already 2 months with child. So they had no, but the court wants that for another day, we can do that.
Yes, I would prefer that if you don't mind.
That'd be
I
perfectly
think
fine
our
now.
DNA test will answer the questions for us.
Okay, sure.
All right, so Mr. Bliss, you're welcome to stay if you like, or you're excused for today. We've dealt with the aspects of your case. You will be required to participate in that DNA as well as to rejoin us November 28th at 2:30. Any questions? Okay, thank you for coming in.
Thank you, Your Honor.
All right, Ms. Thomas, as it relates to mother's initial disposition.
Your Honor, given that we did not proper of the court report or the case service plan.
Okay, hang on, and it might just be us in the courtroom, but actually your microphone is worse.
Judge, given that I don't have a court report or the case service plan, I understand that it was just a 10-day turnaround, making it very hard for that to be done promptly. I would ask for a quick recess so that it could be emailed to me. But otherwise, I would ask for an adjournment if we're not agreeable to a recess.
I do have some time, a week from today. There must have been a jury trial that is now not happening. If that works for everyone. I also have some time, a pocket of time on Thursday morning, November 2nd at 9.
Your Honor, my client has reviewed it. I've discussed that with her. She has no objections to being ordered into the case service plan. If that sways anybody's opinion.
Do you have an issue with reviewing the court report that was prepared for today?
Well, I don't have the court report, Your Honor, so.
None of us do, I think is the problem.
Right, so. I hate to have dead time, but my client could be given credit for advancing. I don't mind adjourning and me doing the court report another time.
Well, are you available Thursday morning at 9?
I am.
Is everyone else available Thursday at 9?
Yes. Yes.
It's file 23187.
Right, we are back on record this morning for the initial disposition of Ms. Cheyenne Denias. We have adjourned it to allow for review of the court report and the case services plan, which was received late last week, or at our last hearing, I should say. And I think we're ready to proceed. May I have the names of our participants, please?
Good morning, Your Honor. Ariel Berger here covering for Lee Heiss as LGAL.
Nastasia Thomas, counsel for the department. Ms. Moore, can you please state your name?
Macy Moore, I'm the foster care worker with Catholic Charities.
Michael McFarland, representing Mother, please introduce yourself.
Cheyenne Denias.
All right, Ms. Berger, we look forward to the report whenever you're ready.
Sorry, I remuted. I have been able to conference with Ms. Heiss, and she was able to provide me with an update. She was able to complete a home visit on Halloween with the child, who's currently living with maternal grandparents in Jackson County, and her report will be filed as soon as possible. Also, I plan to file the coverage report as well, but she reports that the child is very comfortable with grandparents. He stayed there a lot during his lifetime, and that she would recommend continuing placement pending resolution of the criminal case. And benefit from all services. She also did state that we're giving some time for dad so he can complete a DNA test, but she reports no real concerns for the minor child or his current placement, and would like mom to hopefully benefit from services and work towards reunification.
Thank you. Testimony today, Ms. Thomas.
Thank you, Your Honor. If Ms. Moore can please be sworn in. Thank you. Good morning, Ms. Moore. You say that you are the foster care worker in this case, correct?
Yes.
And you provided a court report with a signed case service plan. Are there any updates or modifications that need to be made to either of those documents at this time?
Not at this time.
Thank you so much. And at this time, do you believe that there is still a substantial risk of harm to the child if he were to be returned to his mother's care and custody today?
Yes.
And can you briefly elaborate why?
He is recently diagnosed with PTSD due to the abuse that he's had on his life, and they are working towards they are doing trauma-based therapy, and it should go till spring, and then they will transition him into normal type of mental health therapy. So at this time, I just don't think it would be the best move.
And so, based on psychological harm and the physical, potential physical harm, is that fair to say?
Yes.
Okay. But the permanency goal at this time is still reunification, correct?
Correct.
Okay. And what are the barriers to reunification right now?
Completing the case service plan, I still need to meet with Ms. Dinius to do our bio-parent interview. We have it scheduled for tomorrow at 2:00, so that is a big one. And then just her participating in her services and showing benefit from the services.
And at this time, are there bond conditions preventing contact between mom and child?
She did just have a hearing about that yesterday, and I discussed with Judge Anzalone that if they were to change the conditions of the bond to do so, to allow the therapist discretion, see what the therapist has to say about Xavier seeing his mom.
Okay. And do you know if Judge Anzalone did issue a modification of the bond conditions?
Yes, that is what she modified it to. They were trying to go just for visits, but then I asked Judge Anzalone to let the therapist kind of help us out here.
And to the best of your knowledge, have you or the agency made any referrals for mom to start any of the services, or has she done anything voluntarily?
I believe that she is starting parenting classes today, or she has started parenting classes, but we will make the referrals when she comes and does our bio-parent interview with me tomorrow.
Okay. And the child remains in the relative placement at this time?
Yes.
Is that correct? And are there any additional needs that the child may have other than, mental health treatment?
Not at this time that I am aware of, but we will still be looking into that.
Okay. And from my understanding, the plan would be for the child's therapist to make the recommendations for parenting time, correct?
Yes.
Okay. And are you aware of any therapeutic parenting time programs that the two of them could participate in when the time is appropriate?
I'm not aware of any, but I will look into that. That's kind of what I was going for when I asked, just so it's not all the way in the deep end. It's kind of slowly integrating into it.
Wonderful. Thank you so much. Is there anything else that you'd like to bring to the court's attention today?
No, thank you.
Thank you. I have no further questions, Your Honor, and would move to admit the court report with the attached case service plan.
No objections.
No objection.
Thank you. They are received. Questions for this witness, Mr. McFarland?
I do. Do you have a proposed therapist in mind?
Yes, for the child or for the therapy visits?
How about for both?
The child is already seeing a therapist at the Child Advocacy Center in Jackson. And then the therapy visits, we have not looked into quite yet. I'm waiting to hear back what the therapist recommendation is.
Are you related to Brene Moore?
No.
Okay, just want to make sure there's no conflict. On my client's case service plan, I know there's quite a lot for her to do. If we were going to prioritize, where should she start her major focus? Where would you say?
I would say trying to participate in parenting classes, and I think housing and transportation is a big one as well.
Thank you. Nothing further.
Questions, Ms. Berger?
No, Your Honor.
Okay, thank you for your testimony. Any other witnesses, Ms. Thomas?
No, Your Honor.
Well, Ms. Moore, I did have a quick question. Do you have a psychological evaluation referral in the works for Ms. Denias?
I will have that for tomorrow when we meet.
Very good. And do you have a psychologist that you typically utilize through the department?
I would have to discuss that with other people from my agency.
All right. Typically, in my experience, Dr. Haugen is available for that purpose, but it takes a bit of time to get that analysis completed. But it is informative on services. Has the child had a trauma assessment or any kind of initial assessment on services?
He has not, but I am in the process of filling out all of the CTAC paperwork for him.
And finally, do you have the case number for the circuit court case?
I do not. Miss Dennis might got the order yesterday.
Okay, it's Denias, just so you.
Oh, I'm sorry.
That's okay. Do you know when the next court date is?
I want to say November 22nd, but I may be mistaken.
That's correct. Okay, all right, thank you. All right, any questions based on my questions?
None here.
No, Your Honor.
No, Your Honor.
Thank you, everyone. All right, Mr. McFarland, anyone you want us to hear from today?
I've asked my client, she does not need to testify, so no.
Okay. Ms. Berger, anyone you wanted us to hear from?
No, Your Honor.
Any comments in closing?
Judge, just real quickly, I wanted to give you that case number for circuit
Yes,
court.
great, perfect.
And it does
Okay,
look like
all
the
right.
next pretrial is 11/22 at 8:30.
That's great. All right, Ms. Moore, typically what we like to see on updates on that piece is a copy of the Register of Actions that shows us the progress, or at least some remarks in the court report on that point. So if you could be prepared for that at our next hearing, that would be great.
I can do that, Your Honor.
Thank you, appreciate it. All right, any other comments then, Ms. Thomas?
Your Honor, we just ask that the court order Ms. Denias into her case service plan at this time to work towards rectifying those barriers to reunification. And it sounds like the meeting tomorrow will be really productive in getting those services started. Thank you.
Mr. McFarland?
Likewise, also order the agency into the case service plan to assist my client, so thank you.
Any comments, Ms. Berger?
I have nothing additional, Your Honor. Thank you.
I have some time for our first regular review on Monday, January 29th at 10 a.m. So that's when your next court hearing will be. We'll give you a copy of the court order on your way out that will have that date on it. That's when we'll look for our next court report and those updates 7 days ahead of time. At the end of today's hearing, Ms. Denias, we'll also ask for your email address. Typically our process here, Ms. Moore, also includes the parents in an email 7 days ahead of time to look at that court report. It'd be great if you could actually meet with Ms. Denias and go over her progress with her in the case services plan if it needs any modifications to prepare her for that review hearing, if you're able to do that. So that there's no surprises at the point in time when it's in front of the court. But in the meantime, I do find that all interested parties were given notice for purposes of today's hearing, and that there are reasonable efforts being made towards the goal of reunification in this case, which is appropriate and necessary at this time. Ms. Denias is open to and is looking forward to services, which is great, as she works on housing, employment, parenting skills, and resolves those criminal issues that pose a risk of harm associated with returning the child to her care. The child will remain placed with his relatives. That is the safest and least restrictive at this time. Of course, Mr. Bliss is indicating that he is not the biological father. He's not asking for placement, would not like to have placement, nor is the other potential father asking for placement. So for all those reasons, the child will remain in his relative place where he's doing well, pending our next review hearing. Thank you to Ms. Berger for covering for Ms. Heist, who was able to meet with the child and satisfy her applications.
Thank you, Brett.
And thank you as always to our advocates. Unless there's any questions, that's all for today, and we'll look at the case again Monday, January 29th at 10 a.m. You're welcome.